You don't question it at all. So it is a common scenario, unfortunately.
Bobby in Stevenage, he and his partner split up in 2008. Good morning to you, Bobby.
Morning.
Morning. What happened in your experience then?
Well, like you just said, me and my partner split up in 2008. For the next 2 years, 2.5 years, I had the children 50% of the time, overnight, so 3 nights a week. I used to take them to school and all that. And then at the end of 2010, she just decided to stop me seeing the children. So
why? What was the catalyst for that?
I don't know. I still don't know now.
Had you got a new partner?
No, I didn't have a new partner. I don't know if she did. I don't know. She made some false accusations of domestic abuse, which is an easy way to stall it for a few months in the court. And so she done that. And then just escalated from there. And with the parental alienation, not seeing a parent is enough to alienate. You don't really even need to put anything in their head,
So how have things kind of panned out since 2008? I mean, here we are nearly 10 years on.
Yeah, I know. I can't believe it when I think about it that long. But so we stopped seeing each other in 2010, and then we started court. I stopped seeing my children in 2010. I started court proceedings. That went on for 2 or 3 years, and it ended that they decided on the balance of probability that I'd assaulted her one time years ago, and that I shouldn't see the children.
Is that quite common, Joanna, this business of people accusing the other partner of being violent some years down the line as a way of stopping access to children?
Unfortunately, legal aid used to be granted for Children Act proceedings if it was means and merits tested, if you met the threshold. So if you were under a certain amount of income and savings, and then there were enough merits there, you could bring an application with legal aid. Legal aid then was dramatically cut back, but the one way you could get it was if there had been domestic violence. And I think, and this is only a personal opinion, I haven't got any research to back it up, that as a result of this, people are alleging domestic violence because tactically, if you can't afford a solicitor and you're alleging violence, that's your way to get legal aid. I may be cynical, but I've been doing this for quite a long time, and it does seem to be a link. And so I can't comment on any case, obviously, but it's something which is not, again, as I said before, uncommon.
Bobby, have things been sorted now? Do you see your children now?
No, I haven't seen them I haven't seen one of them for 4 years and the other one for 3 years. No contact whatsoever.
Was there contact ordered, Bobby?
No.
Any indirect contact? Well, indirect means letters, emails, Facebook, texts, anything where you're not actually physically seeing them.
What happened was, for the 2 years that the court case went on, I had supervised contact, and I ended up being the longest supervised contact in this country's history, public or private law, and I've got proof of that. And then it got to the point where the judge decided on the balance of probability that I'd assaulted her, so obviously not to the criminal standard, to the civil standard, and said that I need to go on this domestic abuse program, and which I just flatly refused to do, not out of stubbornness, but because I'm not a domestic abuser, and I haven't been given the right to a criminal trial. And the reason I haven't been given that right is because I was never taken to court for it, because there's not evidence to say I've done it, because I didn't do it.
But here's the issue: if in a Children Act application a judge finds that there has been abuse, then the only way that he will be able to safely say contact should take place will be if the perpetrator of that abuse addresses the fact that there has been a finding and goes on a course. Now, it may be you're telling me you didn't do it. I don't know. I don't think about it. But sometimes one will go on a course simply because if that is standing between you and your children, then that has to be the only option. Now, I understand what you've said to me. I never did it, and therefore why should I go on a course? But the fact is, because you haven't gone on the course, you haven't been. The court has no remedy in allowing you access to your children because you haven't taken that step. Its hands are tied.
They have. They can try me on the criminal standard.
Well, no, it's not a criminal case, is it? Children are not. It's not a criminal case, and if you've been findings in it, if there have been findings at that level, then as I said to you, you have a remedy open to you to address it, which is to go on the course.
It's a criminal accusation, so the next accusation could be that I've abused the children, and then the court could find on the balance of probability I've done that, and order me on a sexual abuse course. So where does it stop? So eventually you.
But it has ordered you onto a course, hasn't it? But you haven't gone onto it. Therefore, it can't say it can adequately protect the children if you haven't addressed.
I wasn't tied to the criminal standard. I wasn't given that human right that guaranteed Article 6 of the Human Rights Act guarantees me that. I wasn't given that right.
No, I understand that, but you weren't tried in a criminal court. This is a civil standard, a balance of probability.
But isn't that bad that if ultimately Bobby has been accused of something he says he hasn't done, that he would then have to in some way go on this course, which seems to have an admission of guilt then by going on the court.
There will be an admission of guilt, yeah.
Exactly. If he hasn't done it, then his ex has really, forgive the expression, got him by the short and curlies.
Absolutely. You're completely right, and you're pushing an open door on this. However, you have to work within the law, and if a judge, there are people that are, and this is nothing to do with you, there's other cases, in criminal cases, people that put in prison and they haven't done it. But if a court finds that you have, on the balance of probability, perpetrated abuse, then it cannot allow you contact with children unless it's supervised, or if it feels that you are a threat to the children, it won't allow it at all. So you have to sometimes suck it up. Go on the course.
So Bobby, you're going to have to suck it up if you want to ever see your children again.
Well, no, because I'm never going to admit to something I haven't been given a fair trial to the criminal standards.
Well, as we've just heard then from Joanna, you're never going to see your children.
Well, I will, because when they're older, they'll come and find me, because I've been protesting since. Because I'm not willing to admit that I'm violent against women when I'm not.
And I can accept that, and I don't think I would ever want to go on one of those courses if I hadn't done anything wrong either. I would think, why should I?
I completely understand that. Let me be clear on that. However, principles sometimes will stand in the way of an ultimate game, and sometimes you have to look at what you need and what you want. And if your ultimate remedy is to see your children, you may have to put those principles on hold.
Bobby, thank you very much. A man who we're just calling Ralph in